Welcome everyone to our webinar on readying your business for success in 2023. My name is Sarah Aldersley. I'm a practice leader in LegalVision's corporate team. I'm joined today by my colleague Lauren McKee, who is a senior associate in LegalVision's commercial and data protection team. Just before we begin, there's just a couple of quick housekeeping items. So after the webinar, you're going to be emailed the recording and the slides. If you have any questions during the webinar, please submit them in the chat box and we'll answer as many as possible after the talk. And also please complete the survey after the webinar. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any legal advice. To request your free consultation, provide us with your contact details in the survey that appears at the end of the webinar. So today we will be discussing protect your intellectual property, ensure you have the right business structure in place, mitigate risks by using contracts, hire and incentivize employees, and comply with data protection laws. As I said, at the end of the webinar, we will be answering some of your questions. So if there are any questions that you'd like to ask, please submit them throughout the webinar through the chat function, and we'll do our best to answer them at the end. And now Lauren will speak about protecting your business's intellectual property.
Excellent, thank you so much, Sarah. So as part of this webinar, the first thing we wanted to run through today is protecting your business's intellectual property, and that includes protecting your brand, so your business name, logo, and also protecting any other intellectual property you've created, and whether that's any sort of software or particular materials. Obviously, as a business owner, these things are key to your success. So it's important that you take a step and take a minute to think about protecting them in the year that's coming. So the first thing we're going to go through today is protecting your brand by way of a trademark. So in terms of what a trademark is, it's essentially a registrable right. So you can register with the UK Intellectual Property Office to have exclusive ownership over your brand. And when you register for a trademark, we can register either for a name, or we can also register for your logo. So we can register both for your business. When we think about trademarks and we think about really, I guess, logos that when we see them, they bring sort of images into our head. So for example, we think about the Apple logo, or we might think about the big M for McDonald's. As soon as someone sees those images, they know exactly what the branding is, and you sort of tell yourself all these stories about it instantly. So having exclusivity over those marks and making sure no one else can use those marks is going to be super important for your business. So when you're setting up a business, or perhaps you've already got a business but you're developing a new product, a new piece of software, for example, it's important that one of the first things you do is you check and have a look around to see if any other businesses are using the same branding as you already. There's no point, or it's very costly to put in a lot of money into marketing and then realize that someone else is also using the same branding, and perhaps they've got a right to it and they're asking you to stop. So have a look around the internet, do some searches. We can help you with that. We can look on the various trademark registers and make sure no one else has that branding. And then we recommend trying to register your trademark as soon as possible. It is quite a lengthy process, so it takes around 4 months, providing everything goes to plan. So it's good to get in early on that. The other thing just to think about is making sure that if you have plans to expand overseas, that informs your intellectual property strategy, because when we apply for a trademark here in the UK, it doesn't give you protection overseas. You need to apply separately for that. And there's many ways around this and ways to handle this, but it's important to think about where your branding matters to you. Once you've got that trademark registration, the other thing you want to make sure is enforcing that right. So now you've got exclusivity over your branding. You want to make sure that if another business pops up doing something similar to you using your branding, that you can stop them from using that branding. And so typically that would take the form of a cease and desist letter. And if that doesn't result in any action, then we could push that further through the courts. The other type of intellectual property I'd like to touch on now, I guess, is copyright. So copyright is an automatic protection you're afforded in the UK. And essentially what that refers to is that it refers to your legal right to ownership of basically any sort of works you create. So whether that be any sort of written materials, software, a song, these are all the types of works that can be protected through copyright. And generally when that's created, the person that creates that work is the owner of that work, unless we change that ownership through way of contract. So a really good example of that is if you're engaging, say, a web developer to develop your website. Typically, the web developer owns your website unless you've got a contract in place to change the ownership of that website. So super important that if you've got other people developing any sort of intellectual property for you, that you've got adequate contracts in place so that you can assign ownership of that to yourself and you own the intellectual property. The other super important thing is that if you do own intellectual property and you want to let someone else use it, so for example, if you own a SaaS platform and you're licensing that and you're giving people permission to use it, you want to give someone permission to use your trademarks, or you've got a supplier helping you and you want them to have access to all of your intellectual property so they can provide their services to you, we can give those people what we call a license. So essentially permission to use your intellectual property. And what we can do with those licenses is we can put limits around them. So you can only use the intellectual property for certain purposes or for a particular period of time. So I would very much encourage you all when thinking about protecting your business is thinking about the branding and whether you've protected that, and then also making sure that if you've got really important intellectual property that you've created, that A, you own it, and B, if you're sharing it with anyone, you put adequate parameters around that. Sarah, do you want to run through setting up in terms of the structuring of the business?
Yeah, great. Thanks, Lauren. So there are lots of different structures you can use when you have a business. I've put a couple of these on the slide. So, you can just be a sole trader at the beginning, which basically means an individual trading. So that would be, for example, me, Sarah Aldersley, trading as LegalVision lawyers. If you are doing business with another individual and you don't have any formal structure in place, you are technically in a legal partnership. So just be a bit careful here, because that does mean that the assets and liabilities are owned between the partners. So typically what you'll see is that startups will use a company structure. It's the most popular option that we see. Reason being is because there are a few benefits to having a company structure. So firstly, you can limit shareholder liability. So if there's a claim brought against a business, it is brought against the company, not the shareholders personally. It's a really good way of having some flexibility and being easy to expand. You can give away ownership rights in your business to key stakeholders such as employees and investors by giving away shares in your company. And it can also be structured in a more tax efficient way. So if you have different shareholders, you can sometimes choose who to pay dividends to depending on their tax rates. So it may well be that you need a group company structure. At its simplest, this is just a dual company structure. So you have the holding company at the top that fully owns the operating company, like you can see in the diagram. This is beneficial when you have valuable assets, for example, a freehold property or valuable IP that you want to protect from the trading operations. That can be held by the holding company. You might also want to consider having more than one operating company, depending on what's appropriate for your business. So how does a company structure work? So the most important thing to remember here is that the directors are different to the shareholders. So the directors, they're often referred to as the board, they're responsible for management and operations of the business. The default position is that board decisions are made by a majority vote, with each director having one vote. So if you have 3 directors, for example, then you would need 2 out of 3 to agree to a decision for it to pass. The shareholders, on the other hand, they contribute capital to the company in exchange for their shares, but then have no involvement in the operations of the business. There are certain matters which legally require a shareholder vote, such as changing your articles or varying the rights that attach to shares, but otherwise it's the directors who make the decisions for the company. One common misconception that we often see is that directors of owner-managed companies think that they have the same voting rights as their shareholding represents. So for example, a company that's owned by two founders, one founder has, say, 60% of the shares, the other has 40%, but they're both on the board. The 60% founder often thinks that they have control because they have more of the shares. But in actual fact, it's the directors that are responsible for day-to-day management and operations, and both founders on the board. So they have equal voting rights in terms of operational decisions. Unless it's something that the shareholders need to legally decide on, they have equal rights. Ultimately, if you own more than 50% of the share capital, you do have a legal right to remove directors. So you can always fall back on this. But as a general rule, it's best kind of not to just rely on that legal right, because there can be other complications if you're looking to remove a director in this way. For example, if they're an employee of the business, you can't just remove them as an employee as well without coming a cropper potentially under their employment contract. So what we recommend here is it's much better just to think upfront around who owns the business, how you want to structure it, what control you want everyone to have, and then provide for that in your governing documents instead. Which brings me on to the next slide around corporate governance and future planning. So as I said, it's the directors who have responsibility for running the company. So it's really important to think about who should actually be on the board. If you're a founder and you're the only director at the moment, if you give away a board seat, this actually means giving away a lot of control because the other director now has to agree to all key business decisions for them to pass. And other things to think about is, should anyone actually have an entrenched right to be on the board for so long as they are a shareholder? So for example, the founders, you've set up the company, it's your business. Do you want to always make sure that you have a right to be on the board, even if your shareholding proportion is diluted? And equally, should any directors lose their board seat if their shareholding falls below a certain percentage? So for example, if you've got an investor coming on board, they want the right to be a director. If actually they kind of stop putting their hands in their pockets, they get diluted in further rounds, should at some point they lose the right to that board seat. You can also think about veto matters. So this is where there are any critical business decisions that you need to make sure have the consent of, say, a certain director or a certain shareholder for them to pass. So for example, if you're a founder who might be underrepresented on the board, but you want to make sure that anything critical needs to have your say before it can happen, you can have a veto matter in your favour. Equally, you might have an investor who's a shareholder but has no board seat. They may want you to have to come to them for certain things. So how you achieve veto matters is you would include a schedule of the points in your shareholders agreement. You can also give founders casting votes at board decisions if you have an equal number of directors. It might be appropriate in some circumstances, but often isn't appropriate because this obviously does give the founder a lot of control. Also worth planning ahead, always a good thing to do. So it might seem like a long way off if you've just set up your company, but it is always good to think about, where do I want this to go? At some point, do I want to achieve an exit? So you might have heard of drag and tag rights. The drag is where the majority shareholders, if they want to sell their shares to a third party, they can force the minority shareholder to sell alongside them. And the tag is kind of the converse. So the minority shareholders have a right to say, I also want to sell, if the majority shareholders have found a buyer. You can have different thresholds at which these rights apply that are based on shareholding percentages, or they may have to include certain shareholders, for example, the founders, in order to apply. But these are something that we think you should consider thinking about upfront. And all of these rights will be included in your Articles of Association, which is the document which binds all of your shareholders. You may well have model articles if you've just set up kind of through the government website. So we recommend you have bespoke articles which deal with matters like this. And you can also have a shareholders agreement, which more typically includes personal rights, such as any kind of non-compete provisions or the veto matters, for example. So I'll hand back to Lauren now to talk to you about mitigating risks using client contracts.
Thank you, Sarah. So in terms of running your business day to day, of course, there's many contracts that are in place. So the first type of contract I want to talk about is your client contract. So whether you're providing goods or services, typically you'll have a contract with your clients. Sometimes you might also receive contracts from bigger parties. If you're providing services, say, to a large corporate, they might want you to sign their own contract. These contracts go by so many different names, terms and conditions, terms of trade, MSA, SaaS agreements, terms of service. The key thing is what's in the document, I suppose, not necessarily what it's called. In terms of having your contracts in place, the first thing to think about, I guess, is whether or not your customers are consumers or businesses. The reason for this is that if they are consumers, so for example, you've set up an e-commerce website and you're selling clothing to individuals, then the Consumer Rights Act will apply. When that applies, there's certain terms that must be included in your terms and conditions that you'll be in breach of the law if you don't include them. So it's important that you have a think about that. There's also certain rights that consumers are afforded, for example, a cooling off period when entering into contracts. When you're in a B2B arrangement, that doesn't apply. But still, of course, we really recommend having a contract in place. One of the main reasons is it means that both parties can be, I guess, open and transparent and clear on what the arrangement is between the parties. So that includes the commercial terms of what it is that you're going to be providing, what the price is, what the term is. But I suppose more importantly, if you're providing any goods and services, there's sort of two key things we need to be concerned about. And one is that you get paid for the work you're doing. And the second is that you protect your liability. You don't want to be providing goods or services and be responsible for a value higher than what it is you're being paid to do the work for. So in terms of payment, it's very important that your goods or services you're providing are set out super clearly, and people aren't going to expect that you would do extra work, I suppose, for the price that you're doing that work for. So a good example is if, say, you're a web developer and you agree to make someone's website for £50,000 and you've set out what the scope of work is going to be, but then you find your customers just constantly asking you to do additional changes that weren't initially agreed. So it's a good idea in your contracts to be super clear about what's included, what's not included, and also putting in a regime for if changes want to be made that you'll charge extra for that. The other key thing to think about with your client contracts is protecting your liability. So when you're providing goods or services, of course, a myriad of things can go wrong, particularly if you're providing services to other businesses. They might rely on your advice or rely on what it is that you're doing for them. Perhaps you're doing IT services, their business, they can't run their business if the internet's down. You need to protect yourself in this scenario. So some of the key things we always recommend is that firstly, you cap your liability in a contract. So the contract says a maximum amount you'll be liable for under the contract. Generally, you'd want this to just be the value of the contract. Secondly, you'll want to exclude your liability for things that are outside of your control. So this is often called force majeure events. And thirdly, you don't want to be liable for things that are caused or contributed to by your customer. So if you're relying on information they've provided you and that informs your advice, they should be responsible for what they've given you. And lastly, you want to make sure that you're not liable for any sort of consequential losses. So these are losses that stem indirectly from your provision of the services. So for example, you might be providing marketing services to another business. If they don't increase their revenue, you don't want them to turn around to you and say, you're liable for all the revenue that I thought I was going to get next year. You want that to be separate from the contract. So we'd recommend including that exclusion. I'll move on now to using supplier contracts. So this is where you've got people supplying services to you, and whether that's software developers, salespeople, people doing admin work for you, anyone that you engage as a freelancer or a contractor, you're going to have a contract in place with them. I guess it's the inverse here in terms of what's really important. Here, what's so important is that they do a very good job for you and do the work to a high standard. And if they're not, that you can end the contract. And then similarly, you want them to be responsible for the work they've done and make adequate promises to you regarding that, to take ownership of any liabilities that occur, and they take responsibility for that. And you'll also want to make sure that in terms of intellectual property, which we spoke about before, if anything is created, that's assigned to you, that if you're sharing confidential information with them, that they keep that confidential. In terms of liability, I think it's super important here to just take a step back when you're engaging a contractor and think about the risks under the contract, things that can go wrong and things that are completely within the control of your supplier. So some good examples here are things around, for example, intellectual property. If your supplier is making you a website and then they rip off the source code or rip off the website from another website, you have no idea, you put it on the internet and someone comes along and sues you for that. You want to be able to turn around to your contractor, the supplier, and say, well, look, that was your responsibility. It's totally outside of my control. I need you to compensate me for what I've lost there. I think we'll move on now to engaging employees, which I guess is a good sort of link from engaging your suppliers, because again, there's an important relationship where people are providing services to you and you want to make sure that they're doing a good job.
Yeah, exactly. So the first question really to then ask is someone an employee or are they just a contractor? So employees are under an obligation to turn up to work, carry out the work under your supervision or control. They're paid a fixed amount, kind of irrespective of whether they've met performance targets. Whereas on the other hand, contractors are people that they work for your business, they're not really under your supervision or control. You might just engage them for a particular project or on a more ad hoc basis, and they only really invoice for work that they've carried out. The distinction is important because employees have a wide range of employment rights. And particularly when you're at a kind of more startup level, employees need to be paid at least minimum wage. So, you know, when you are starting out, your cash reserves might be a bit on the thin side. So this way you have more flexibility over how you're spending your cash and you're not committing to sort of paying a certain level of salary to an employee. If you do decide to hire an employee, there are a few things that you need to do. If you could just go on to the next slide. Thank you. So, oh, this isn't the right slide, but that's okay. You need to be registered for PAYE, even if you just have one employee, because you do need to deduct income tax contributions at source. You need to pay employers' national insurance contributions. You need to have a pension scheme set up because there's now an obligation to audit enrolled employees. And you need to take out employers' liability insurance. So as you can see, just from even hiring one employee, there is actually quite a lot you need to do. So it's definitely worth thinking about, you know, can I get this job done just using a contractor? Am I at the point where I'm ready for my business to grow and take on employees? If you do decide to take on employees, then it's a good idea to think about how am I going to incentivize this person to stay with my business and work hard. So you can always give an employee kind of a cash bonus based on their performance. But as I said before, you know, if you're a startup, you might not have sufficient cash reserves to do that. You might actually be paying kind of smaller salaries than an employee could maybe otherwise get for other larger companies. So a really good way to incentivize employees is to offer them equity in your company. It also aligns the employee's interest with yours because the better the business does, the more their shares are worth. So it's a win for them as well. So you can incentivize using equity by giving either options or shares. So an option is a right to acquire a share at a later date. If you give an employee a share, then this means they will have voting, income, and capital rights straight away. I mean, you can issue them with a different class of shares that don't have voting rights, but for this purpose, I'll just assume that they have kind of full rights attaching to the shares. So often what happens is the main consideration when you're thinking about, am I going to give someone an option or a share, is actually driven by tax. If you give an employee some shares, which they don't pay anything for, then HMRC will look at this as if they've received income equivalent to the value of those shares, so they'll get taxed. So this is why a lot of companies use options. They can be more tax efficient, especially when you're in an early stage, because there are different option schemes which might be available to you, which give some tax advantages. The most effective tax scheme for giving employees options is called the EMI scheme. It stands for Enterprise Management Incentive Scheme. Under an EMI scheme, the options given to employees must be over ordinary shares with no preferential rights. There are lots of different criteria that both the company and the employee need to meet to qualify. I've put some on the slide, but just to touch on a few. So the company has to be carrying on a qualifying trade. So some businesses are actually excluded. For example, if you do property development, and law firms can't take advantage of this. Some financial services can't either. Also, the gross assets must not exceed 30 million. The company must have fewer than 250 full-time employees and have a permanent establishment in the UK. There are also some conditions for the employee. Again, I've put some on the slide, but just to touch on a few, it's on the next slide. For the employee to qualify, they must be a genuine employee, so not an NED. They don't provide their services through a company. One key one here is that it's either their only employment or they work for someone else, but the work they're doing makes up at least 75% of their working time, or they work at least 25 hours a week. And they also can't have more than 30% interest in your company. So if you do manage to fall within the scheme, both you and the employee, and you're issuing EMI options, the tax consequences of this are that when the employee is given the options, they don't have to pay anything for them, they don't have to pay any tax. When they go on to exercise the options, as long as what they're paying for the exercise price is at least equal to the market value of the shares at the date when the options were originally granted, they don't have to pay any tax either. So it's only when they go on to sell their shares that they have to pay capital gains tax. They don't have any more income tax consequences. So that's where it really, you can see the difference in the first example. If you give someone shares they don't pay for, they will be taxed upfront. They don't have the money to pay for that tax necessarily because there's no kind of exit event. So the options here can be a really, really good way of giving employees eventually shares. So some key considerations if you are going to be giving equity to your employees is obviously the reason why you're doing this is to reward them for their contribution and hard work, but also to try and incentivize them to continue working for you in the future. So often what happens is you won't give them the full value of their equity from day one. So how you achieve this is through vesting. It can apply to both options and shares. So for options, what this means is the employee isn't allowed to exercise their option and receive their shares until the options have vested. And for shares, it means they get the shares, they have full voting income rights from day one, but you say you don't get the right to sell the shares for any value until they've vested. Vesting's normally over 4 years with a 1-year cliff. So what this means is you wait an entire year to then get 25% of the options or shares, whichever way you go for. And then normally it's monthly or quarterly thereafter for the following 3 years until they're fully vested. You can also link vesting to performance if you want. So for example, if an employee meets a certain KPI, then X amount of their shares or options will vest. It's also important to consider leaver provisions. So if you have an employee that you've given equity to and they leave, what happens to any shares or options they have which have vested? So you might want the right as the board to require that employee to actually sell those vested shares or options, either back to the company or to a director or to another shareholder when they leave. They would get market value at this point. But obviously, if you are a small business, you don't have very many shareholders, and you have lots of employees that you're giving shares to, and then they're leaving after a few years, sort of spreads your shareholder base quite thinly. From just an administrative perspective, if you need to pass a shareholder resolution and you've got lots of ex-employees holding shares, you have to keep reaching out to them to get them to sign documents, which isn't ideal. But also just for kind of forward planning purposes, if you do have a large shareholding given to a particular employee, say you had the CEO, for example, and they've left with a lot of the shares, you're wanting to replace them and incentivize that new hire. If you can use the shares from the other person, it's much better than having to sort of dilute everyone again and issue more shares. So it is quite important to think about, okay, I'm giving an employee shares, but what happens later down the line if they leave or something goes wrong and I want to take their shares off of them. So I think I'll leave that one there and hand back to Lauren to talk to you a bit about data protection.
Thank you, Sarah. I'll run through some of the key concepts of data protection laws in the UK, but I do know that this is usually quite business to business, very specific. In the UK, the privacy landscape is governed by the Data Protection Act, and under the Data Protection Act is the UK GDPR, which largely mirrors the EU GDPR. It's important that you comply with data protection laws because the consequences and fines of not doing so are quite extreme, and also the reputational damage of not complying with data protection laws is certainly not something you need your business to fall into. In terms of what the data protection laws cover, the first thing to think about is what is personal data. So essentially that's any sort of information that relates to an identifiable individual. So we're talking here about people's names, images of people, their passwords, any sort of health information you receive, that's all personal data. Under the GDPR, there is a concept of a controller, a data controller and a data processor. So some businesses are one or the other, some businesses will be both. A data controller is a business that determines what data they're going to collect and how to collect it. So examples would be an e-commerce business, someone comes onto your website, they put in their name, their delivery address, their billing address, their payment details. You're choosing what information to collect and then processing that. We also have the concept of data processors. Data processors process information on behalf of another entity. So an example here would be SaaS businesses. For example, if you're using any sort of CRM and you input lots of data about your customers or your staff into the platform, the CRM provider should certainly only be using that information or that data on your instructions and not using that personal data for any other reason. And so they would be classified as a data processor. Under the data protection legislation, there's different obligations on data controllers and data processors. So that's why it's good to identify which category you fall into. In terms of key things to think about, I guess doing a bit of a data audit on the business is making sure that the types of data you collect, you've got a lawful basis to rely on when you're collecting that. You're not just collecting information that is totally unrelated to what you're doing. You're making sure whether it is that you need consent or if you are performing a contract, that there's a reason that you're collecting it and a lawful reason you can rely on. The next thing is making sure you've got a privacy policy. So individuals have a right to be informed under the GDPR. So you should be transparent about your privacy practices. Taking a look at your website, if you're collecting any sort of cookies, you should be making your users aware of this and giving them the option to choose whether you track that information or not. And lastly, having a look at your marketing practices. So are you sending email marketing, which most businesses do these days, and have you got the relevant consents in place in order to do that, noting that it's very different whether someone's an individual or like a consumer, or whether you're sending B2B marketing. I might leave it there, but if there's specific questions on this, very happy to answer them.
Great, thanks, Lauren. We've actually also put together a UK startup manual, which you can download from the handout section of this webinar. It goes into similar topics of what we've discussed today, just in a bit more detail. So you might find that useful if you want to download that. There's also another upcoming event that may be of interest for you on the 21st of March at 10 o'clock called Legal Essentials for your website. So you can register at the website that's showing on the slide right now. We will move on to your questions next. To give you a chance to sort of submit any while you're thinking through what questions you might have for us, we'll just take a minute to tell you about our LegalVision membership. So LegalVision's membership is a cost-effective alternative to the expensive hourly rates that you may experience with other law firms. So how it works is for an affordable monthly fee, you get cost certainty and all-inclusive legal services. So that includes things like unlimited document reviews, drafting, amendments, so for things like business contracts, commercial leases. It also includes unlimited advice consultations, such as business structuring, employment, disputes, so on, and unlimited UK trademark registrations. So LegalVision membership is kind of like your own legal in-house counsel. We'll take care of all of your business as usual legal work. You can then just focus on running your business. You can request a free consultation when the survey appears at the end of this webinar if you want to find out more, and we'd be happy to talk you through how it works. So we'll now move on to answering some of your questions. So Lauren, do you want to take one that's come in?
Sure. The first question I've got that's come through is about using NDAs in addition to your contracts. So essentially an NDA, what that is, or a confidentiality agreement, is a document that sets out that a party, or perhaps both parties, is agreeing not to share confidential information for any reason other than what's been agreed in the NDA. Typically, NDAs are used in the first instance of negotiating with another party. So perhaps you're engaging a supplier, a manufacturer, you want to get some quotes, but you need to share with them confidential information about your business. We'd certainly recommend putting an NDA in place at that point. Of course, when you actually engage someone, you're going to want them to keep your information confidential as well. But typically, we'd build that into the contract you've got with your supplier. Because when you're in your initial stages of using an NDA, you might be talking to, say, 5 different manufacturers, and you want them all to keep your information confidential, even if you don't actually proceed with their services. Whereas once you've proceeded with someone's services, I guess terms around the use of confidential information might be a little bit different now. You're happy for them actually to use that information to provide services to you instead of just, say, providing you with a quote. So we'd build that into the supplier agreement once you've decided to engage someone.
Right, yeah, there's a question for me in here. So when would I need more than one operating company? So this is where, if your business is structured, so for example, you run a chain of restaurants and each restaurant's from a different premises, you might want each premises to be owned by a different company. You might have a separate company that employs all of your employees, or you may have each company employing just the employees for that site. But really what that means is sort of any costs, any contracts that go just to that one restaurant can go through the one operating company. Firstly, this helps kind of protect your assets between the businesses. If one restaurant in one particular area fails, you know you've protected the others. It can also be good for accounting purposes if you want to be doing individual accounts for each business. Everything's sort of going through the same entity and it's a bit easier to keep track, things like bank accounts, etc. It might also be the case that you have a business that has kind of a few different arms to it. So for example, you run a website-based business, but actually you're going to branch out and do some products as well. So you may want to distinguish between the two, because you've got your kind of SaaS company that is working well, and you don't want to impact that by starting something a bit different. So you might want to hive that across to a different operating company that's still owned by the same holding company. There's another one which looks like it's probably also for me. So what if you find out your co-director is sharing sensitive business information with a competitor? As the only 2 shareholders in the company, how do you get the other director to leave rather than keep damaging the company? So this is a bit more of an in-depth one, but I guess we see this quite a lot, where there are just sort of 2 directors, 2 shareholders, and something goes wrong, which in this circumstance sounds like, it's somebody that's sharing business information, but it could equally be something else. I think there's a misconception that you have the right just to sort of get rid of somebody and, take their shares off of them if they've done something wrong. What we would do is we would need to have a look at kind of what you have in place with this person. Going back to what we discussed earlier, like, are they actually an employee? In what capacity are they working for the business? What terms have you signed up to with them? Do you have an employment agreement in place? Is there any sort of performance management you need to do? If they're just sort of more of an NED or a contractor, it's probably easier to terminate them if you have a contract agreement in place, if they've clearly breached that. But otherwise, if you have kind of no agreements in place, you really are just relying on directors' duties under the Companies Act. So each director has a duty to act in the best interests of the company and the shareholders as a whole. They can't put themselves in positions of conflict, things like that. So what you'd be looking at is going down that route and saying, you've breached your director's duties because you've done something that clearly is harming the company. Again, if you have kind of bespoke articles or a shareholders agreement in place, hopefully they may have provisions in there which sort of, if there is an event like this, it triggers a scenario where they can come off the board and you can take their shares off of them. If you don't have that, then you may just be relying on sort of general Companies Act legislation. So you may well be able to do something with them being a director, but you won't necessarily be able to take their shares off of them as well. So it can get a little bit complicated, and it's something that we do advise on all the time. So more than happy if you sort of want to book in, whoever asked that question, if you want to book in a consultation afterwards, and we can sort of talk you through how we assist and go from there.
Sarah, just a question from me that you touched on then in terms of the shareholder agreements articles. How often do you really see those the rights under there being enforced?
Yeah, well, hopefully you don't have to rely on things that would be effective in this scenario. So things like the leaver provisions. But as I say, like, it is more common than you would think, unfortunately, when you have a scenario where maybe someone's gone rogue, or maybe they're like wanting to set up on their own, and there's been a fallout. So, you know, if you don't, as I said, if you don't have those rights in your articles or a shareholders agreement, then in terms of shareholdings, you are pretty stuck. You can't force somebody to sell their shares. You have to come to the negotiating table, often obviously come up with a price that you're happy to buy the person out at. So it is really, really important to sort of look ahead and think, okay, you know, I'm setting up this business with someone else. Don't want it to go wrong, but what happens if it does go wrong? You know, in what scenarios are we both happy that we have to step down? So yeah, you do see it quite a lot, unfortunately.
Okay, it looks like there's one more question which I'll run through, which is about trademarks. Is there a limit on the number of trademarks I can register? We can go ask Apple that question. So in terms of registering trademarks, there's no limit on how many trademarks you can register. As I said before, you can register a business name or logos. Many businesses will register lots and lots of different trademarks. So perhaps it's not just the business name, but if you've got different products, so you might be a software company with multiple different products, you'd be looking to trademark all of the different product names, because you don't want people operating a competing business with the same product name. Similarly with logos, the bigger a business tends to get, then typically there's more and more logos that they want to protect. I suppose the thing to think about, I guess, from a financial perspective, is that you do need to pay for every application. There's government fees associated with that. So usually we'd recommend focusing on, well, what's super important to you initially. In particular, the brand name, particularly if your logo maybe only just says your brand name in it, you might want to focus on just the brand name. But having a view going forward and what's important to you and what products you've got that you need to make sure other businesses don't take from you, then certainly that there's no limit on the number of trademarks you can register for.
Great, I think that's probably all we have time for today. As I said before, we'd really appreciate it if you could just complete the 30-second survey that will pop up when we leave this webinar. If you do want to receive your complimentary legal consultation, then please make sure you're including your contact details in that. If you're already a member, then feel free to book in any legal advice consultations that you need. Thank you so much for joining us. Speak to you soon.
Thanks, Sarah.